So it's the day of the deposition and you want to know, how does the deposition start, end, and then what's the next step? Well, stay tuned. In this video, I'm going to share with you deposition procedure, what happens after the deposition, and how are deposition transcripts actually used in your case. Hi, I'm Naomi from Gonzalez Law, Legal Insights from California Attorneys. Welcome to part 4 of our deposition series, Acing Your Work Comp Deposition. This video is part of our mission to empower clients everywhere through education on the legal process. Please support us in our mission by liking this video so more people can ace their depositions. Deposition procedure, how does it actually start? The court reporter will ask you to raise your right hand, ask you to repeat a statement. This will be placing you under oath, meaning that you must tell the truth. If you lie on purpose, you can be prosecuted for perjury, which is a felony. After you're under oath, the defense attorney will start some ground rules and remind you have an obligation to tell the truth. If you lie under oath, that you can be prosecuted. Also, they're going to remind you that you have to say yes or no instead of saying uh-huh or uh-huh, and that you have to wait for your turn to talk. You can't talk over each other because the court reporter is going to be writing things down. As soon as a word leaves your mouth, the court reporter writes it down. So the defense attorney is going to start their questions, and that's going to start the direct question segment of the deposition. After the defense has finished the direct questioning segment, your attorney can choose to ask you questions. They do not have to ask you questions. In fact, if they choose not to, that's probably a good sign that everything went well. However, I will usually ask questions if I feel there was any part that needed to be developed more that could work in our favor, or if I found that my client actually told a lie and I need to correct that so they don't get in trouble later on. However, this can be kind of risky because if you ask them a question and they told you something different in prep than they are on the deposition, then you can actually make things worse for yourself. So that's why a lot of attorneys choose not to ask questions and just leave things alone. After your attorney has asked their questions, the defense attorney has another opportunity to ask questions as a follow-up, and then your attorney will have one more opportunity to ask questions. After everybody's done with their questions, the deposition will end in one of two ways. One, by stipulation, where both sides will decide that they will stipulate to search an agreement at the end. Or it will end by code, where there is no stipulation, just what the default of the code is. After the deposition, it can take 2 to 3 weeks, maybe up to a month, to receive your deposition transcript. These transcripts look kind of like a Hollywood script. It has a person's name and they're lying, the other person and they're lying, all the questions, all the answers. What your attorney is going to do is they're going to ask you to review that document to make sure everything was written down correctly. Every attorney's office has a different protocol for that, whether it's emailing it to you, mailing it to you, asking you to come in. Double check with your attorney as to what they prefer for you. But either way, you're going to review that transcript to make sure everything is correct. Usually it is, because court reporters are very good at what they do, but court reporters are human, so they may have made errors. If there is an error, there will be a corrections page. You can correct that error. However, if it is something that is important, just know that the defense attorney can comment that you did make that change if you were to go to trial. That shouldn't stop you from making the change though, because you're going to have to sign it under penalty of perjury that everything is correct. So how will these deposition transcripts be used? They'll be used usually one of 3 ways. One, they will be sent to your doctors, whether that's your primary doctor or your qualified medical evaluator, to help them understand your injury better and help them with their diagnosis and all of their opinions and their final report. 2, they'll be used for subpoena purposes. If you've talked about various facilities you treated at, they may subpoena records from those facilities to make sure they have a full picture of your medical history. 3, they're going to use the transcript for impeachment purposes at trial. Now keep in mind, most cases don't go to trial. They settle before then, so this may not even be an issue. But if at the deposition you gave a different answer than you did at trial on something that was important, they will use that against you. For example, if at the deposition you're asked, what color was the traffic light when you got in a car accident? And you say it was red. Then in the trial, you say it was green. Then they're going to say, well, you were under oath at the deposition and at trial, and you gave different answers. So which one is it? And why are you lying on one of them? And you'd have to try to explain your way around that, and that's not a good position to be in. So that was part 4 of our deposition series. Next time, we're going to be talking about mistakes to avoid at your deposition. If you would like us to represent you for your deposition, go ahead and call us or text this consult, and we'll be very happy to talk to you about that. Thank you. Bye. Usually they are, because court reporters are usually very good, but people are people. But people are human, and sometimes people make mistakes.
Everybody's human.
Okay.